Hi everyone, Christina Koshman, Senior Tax and Estate Planner with MLD Wealth Management Group of Canaccord Genuity. I'm here today to discuss some of the softer issues surrounding estate planning. Far too often we tend to focus on the technical parts of estate planning and we don't focus on what really matters, the why. Why are we doing this planning? What are we really trying to achieve by completing this type of planning? Even when I pose that question to my clients, sometimes they're even shocked by their answers. So today I'm joined by Rolland Lequier, founder of Elite Counsel. Rolland is an established Calgarian lawyer who has devoted his practice and career to estate planning. I've had the good fortune of working with Rolland on files for 20 plus years, and both myself and my clients value his advice and his guidance. Welcome, Rolland.
Hi, Chris.
So, Rolland, I know that estate planning is guided by both rational and emotional motivations. So maybe we could start off today with some questions people should be asking themselves prior to meeting with you or I, so that they understand why they're doing this and what they're trying to accomplish.
Certainly, Chris. There are a number of emotional situations, emotional questions that come into play, particularly around situations that clients are in. For example, today we deal with a lot of blended families, people that have been remarried, perhaps they have children from a first spouse, and questions will often come up with, well, how do I protect my second spouse and still give due regard to what I want to leave to my children from the first relationship, first marriage? And there are a lot of competing issues there. Perhaps you want to use a trust to put money away for a spouse and have the remainder protected for your children. And of course, a question comes up with, well, how long will that last? Are the children simply waiting for the spouse to pass away so they can get their inheritance? That can lead to a lot of hard feelings and a lot of difficult emotions after the fact.
Mm-hmm.
Another situation will be families that have multiple kids. And maybe it's a family business or a family enterprise where one or more of the children work in that family business. And the question becomes, well, what is fair? Is it equal? Has one child contributed more to the care of their parent and perhaps they share more at the end of the day? That can lead to a lot of difficult conversations amongst the children. There can be, the children may have their own thoughts as to what they deserve. And believe me, those meetings can be fraught with a lot of emotional and stress.
Yeah, I'm even going to touch on, fair versus equal in the business estate planning world comes into play a lot. Especially if you have one child that works in the business and the rest have zero interest, how do you make that fair for everybody? Because it's not going to be equal because, that one child that works in the business probably thinks he should inherit the entire company, but then how do you equalize it with the other kids? Any comments on that?
Yeah, oftentimes if you're trying to benefit a child, it could necessitate the sale of an asset or mortgaging an asset, and you don't want to hamstring the future success of a business just so that you can pay out all the children in an equal fashion. Sometimes fair is not equal, or we have to look at different options in terms of how we can benefit the children, perhaps through financial assets, through life insurance. There's a number of options that your financial advisors can work with.
Yeah. So should people be discussing things with their family members prior to planning, like with their children, to get an idea of maybe what the expectations of the children are, not necessarily, having the children dictate what their plan should be, but just understanding what they're expecting?
Yes, I certainly recommend that for a couple of reasons. One, if children have an expectation and we prepare a plan that is completely contrary to it, then we are going to deal with a challenge. I mean, children can be very upset after the fact, and oftentimes it's too late if we're learning about these things after the death of one of the parties. So certainly having the children giving us their voice, telling us what if anything, they expect out of the parents' assets. And you have to kind of dig a little bit. You have to get beyond the initial, oh, our parents worked hard for their money and they should spend it in their lifetime. When in reality, they, or perhaps their spouse, is talking in their ear saying, you deserve more. You should get more than your no good brother. You contribute to this business, and that should be paid at the end. So we really have to dig and get to some of the hard answers, some of the beyond the superficial. And certainly I recommend kids being a part of these conversations.
Now, recommend the kids being part of the conversations prior to them coming to meet with us, or maybe even bringing the kids to the table as a family meeting first go around to discuss all of these types of challenges?
It certainly depends on the situation. We have worked with a number of families where we have the children sitting at the table with us, with the parents, and sometimes that works. Other times they'll just give us the superficial, well, mom and dad, you deserve to spend your money and you don't have to leave anything to us. Mm-hmm. When an advisor gets those kinds of questions or kinds of answers, then it's necessary to kind of dig a little deeper and maybe have separate meetings with the kids to get at really the root of their positions.
Yeah, good point. So what about after the plan's developed? Do you think it's a good idea to give copies of their documents to their loved ones, or do you think it's more beneficial to have, the entire, next generation, or the people who are going to be inheriting the wealth and the legacy of the family, to sit down with mom and dad and their advisors to go over the documents, to talk about how it's structured and what they can expect, to answer any questions or concerns they might have now, instead of trying to or instead of shocking, I guess, the kids later when mom and dad pass away?
Yes, I do recommend the family meeting where once the plan is done, what we do as lawyers and financial advisors, we sit down with all the parties, including the kids, and we can review the plan in as much detail as the parents are willing to share. We don't have to get into specifics in terms of how much each child will get. It could be put in broader terms, or if the family is completely open with that sort of conversation, then we can get into the specifics. But you're right, getting some indication of whether children are agreeable to the situation is a good idea. If we need to change it, we can certainly do that while everyone is still there. And secondly, a lot of these documents do have technical requirements as to why we're doing things. There can be a different tax effect if we give an asset to a child as opposed to a spouse. So we want to explain the rationale, some of the reasoning behind it, some of the technical requirements. And some of that gets lost in translation if the client is trying to do that on their own, and having them in the room with us where we can address their concerns, we can answer their questions. I think that's always a good idea.
Mm-hmm. And I also think, I'm just going to add more of a comment than a question here, is I think when we do those family type meetings, it also reiterates what the parents have done in their documents, and it gives them a better understanding, even themselves, of why they have put in, a trust versus giving a direct bequest. Do you think?
Yeah, that's right.
Yeah.
A lot of times we'll have clients come in for a review, maybe 5 years later, and they tend to forget, geez, I forgot that we talked about using a trust for our children. And maybe now that trust isn't necessary because they've become a little wiser, a little older, a little better with money management. And we can always tweak the plan as times come. But you're right, people often forget the rationale and the reasoning behind we do things when it's 5, 6, 7 years later.
Right. And I guess that kind of leads into my next question is, how much information should we be giving the next generation, and when's the right timing? Like myself, as a mom of 2 teenage boys, there's no way I would want to be having this conversation with them on the financial aspect of things, but definitely I've already had the conversation with them about, who would be taking care of them if something happened to me, and where they would be living, and let them know that they would be financially okay. But when do you think is the right time, or do you think there's a right time to really delve into the nitty-gritty details of it?
It's always dependent on the situation, as you can well imagine. As you know, sometimes we talk to parents and we discuss, well, how do your kids get along? How astute are they with respect to financial affairs? Do they have a spouse of their own that would be influencing their position on these things? And a lot of parents will say, oh, my children will never fight. They get along so well, when in reality, when money's at stake, there are a lot of fights and a lot of challenges. That's just the practical reality of things. So every family is different. We treat each family with respect to its own circumstances. And we allow the parents to give us some feedback as to when they think their children are able to handle the discussions that we're having. But the sooner the better. I mean, that's how children become better at money management, is being involved in these types of discussions. If the situation is such that a medical question is required, if the children have an opportunity to have that conversation with their parents in advance, hopefully they're better prepared to make tough decisions when the time comes. So every family is different, but we certainly encourage it sooner than later.
Yeah, yeah. Okay, well, I think I really touched on, some of the aspects that I wanted to touch on today. Do you have anything else you'd like to add, when it comes to planning now so you don't have to fix later? I mean, you deal with a lot of probates, you deal with a lot of families who come to you after the fact, some that you prepared their documents for, some that you didn't. Is there anything that you would just want to add to today's conversation to get our clients and people thinking about other conversations they might want to have with their children in addition to this?
Sure, 2 comments. First, a will kit is never a good idea. So if you have a client that is considering the use of a will kit, please do not. Maybe you save some money now, but you're going to end up paying us later. Mm-hmm. And secondly, involve as many of your family members as you can with these conversations while you're still here. Certainly when you're gone, it won't matter to you, but it will have an effect on your family. And if you want them to get along, if you want them to remain a close, cohesive family, then you have to address these issues. And we may as well do it when we still have time to fix it, if necessary.
Can I ask you one more question? Just expand a little bit more on the will kit. I know a lot of your business is doing probates for family members and trying to fix the mess that was created. Why is a will kit not good? I mean, I know the answer, but can you explain it for our viewers today?
Sure, there's a couple reasons. One, they're very rarely prepared properly, in that they don't use the proper language that is dispositive in nature. So a will has to, by definition, give away assets when you're gone. And it has to be clear as to what you're trying to give away. If you say, I give my, ring to my oldest daughter, but you have, 5 different rings, the daughter's likely going to choose the most expensive one as the one that was included in that will kit, when the other children might disagree and say, well, no, that meant the one that you gave her, not the huge diamond engagement ring that dad gave her. So certainty and clarity in the language is often lacking in these will kits. And secondly, they're often not signed properly. There are technical requirements in order to constitute a will. You need 2 witnesses. The witnesses cannot be beneficiaries. And if they are, the gift to the beneficiary fails. So often you'll have a husband and a wife do a will kit together. They sign it for each other. And as a result, the gift to each other fails. And you don't want to see that. Certainly pay the money, see a qualified advisor. We'll help you get the document done properly. And believe me, there's lots of options in terms of addressing complications within your family unit. Certainly worth the cost and effort.
Mm-hmm, definitely. And I think I'm going to do a whole video presentation on that, tips and tricks to avoid, or mistakes to avoid, I guess, in your estate planning, so that you can avoid the family feud situation. So I guess we'll take that onto another video. But I think these are all great things to think about. I think that's a good place to break for today. Thank you, Rolland, for joining us, and thank you all for listening today. And stay tuned for more videos on legal and financial planning topics. Take care. Thanks, Rolland.
Have a great day.